Okay. All right. Hello, everyone. Thanks for joining. We're just going to give people a few minutes to join the webinar, and then we'll get it kicked off. So we'll be starting here in just 2 or 3 minutes. Okay. Well, it's a couple minutes past the hour, so let's get going to respect everybody's time. So welcome everyone to this to our webinar on foreign sourcing and government contracts. My name is Zach. I'm part of the marketing team here at DEWALT, and we're very fortunate today to have Shelia Armstrong and Tara Hopkins from K&L Gates, who are an external counsel partner to Stanley Black & Decker. And so we're willing and happy to lend their expertise on this very important subject. I know many years ago when I was a contractor, this topic almost bit us pretty good when we were trying to fix up a bridge, and we had one item that was just over the limits and got into these foreign sourcing, and it was definitely a pain. So I know how topical this is with all the new government bills that are out there. So I'm really excited for this topic. Just a couple of little operational notes. Please use the Q&A feature to ask any questions. Myself, Shelia, and Tara will be monitoring the Q&As. If we can't answer the question with just a simple text, we will save it to the end during the Q&A session, and we'll try to get everything answered. Please keep the questions high level. If you have a very specific topic, pressing need that you need help with, Shelia and Tara's contact information will be provided. So, if you need that detailed help, I'm sure they'll be happy to set something up and really be able to dive deep and help you figure things out. And also, we will be providing a PDF copy of all the slides you see here today. So I'll be emailing that out after the webinar. And I think with that, I'm gonna mute and go off camera and pass it over to Shelia and Tara.
All right, thank you, Zach. And Tara and I would like to thank Zach and Stanley Black & Decker for giving us this opportunity to speak with you today. It's a little bit of a confusing topic, so we're going to try to simplify it as best as we can for you. I have my own little housekeeping issues that I need to go over as well, which is by this webinar, we're not intending to provide legal advice to any of your companies if we don't already have an existing attorney-client relationship with the company. And we're not intending to form any attorney-client relationships by providing this information to you today. And then, as Zach mentioned, we're happy to answer your general questions. If you have a very specific question related to a project that you're working on now, we recommend you either reach out to your counsel, or if you don't have counsel in this area, our contact information is at the end of the presentation, and we'd be happy to talk with you. So with that, moving on to our next slide, please, Tara. All right, so this is our agenda for today. We're going to talk a little bit about Buy American Act and Trade Agreement Act, which you may all be familiar with. And then we'll move into BABA, which seems to be the hot topic of the day. We're getting a lot of BABA questions now. We'll talk a little bit about the OMB guidance, and Tara will talk more about this in the substantive slides on this, but I'd just like to point out that this is in fact at this point in time guidance that's been put out by OMB, and until the agencies actually adopt this guidance, they are not agency regulations yet, but we're starting to see some proposed rules, and I'm sure we'll see a lot more on that as we move forward and the infrastructure funds start rolling. And then we'll conclude with some enforcement and best practices. So next slide, please. And one more. Okay, this is a question we get a lot. You know, we buy this product in China, we make this product in China, can we sell it to the government? And the good legal answer to that is it depends. It depends on who's buying it. It depends on Chinese content versus domestic content. It depends on, you know, are you buying parts from China and manufacturing in the US? And most importantly, what regulations apply? And that what regulations apply is often something that's a little bit hard to figure out. You may get a request that says, we need a Buy America cert. Okay, well, what does that mean? And if we go to the next slide, we can see that there are all different sorts of regulations that you may be asked to certify to. So just kind of a high level overview of what these are. And then on the next slide, we'll talk more about how you know which one applies. So the Buy American Act, the traditional Buy American Act, is the regulation that requires that products sold to the government be manufactured in the US, and that with the exception now of products that are predominantly iron and steel, they contain at least 55% domestic content, or they qualify as a commercially available off the shelf or COTS item. So a COTS item is one that you can basically pull off the shelf and sell to government or commercial. It isn't uniquely governmental. It requires that you actually do sell the product commercially in substantial quantities to qualify as COTS. But if you can get that COTS exception, then you don't have to worry about your content requirement for products that are not predominantly iron and steel. Now, a couple of years ago, we had this change to Buy American that requires that for products that are predominantly iron and steel, and this is products that exceed 50% iron and steel by cost, they have a 95% US content threshold. So they need to be manufactured in the US and contain at least 95% US content, much higher threshold than we had in the past. Trade Agreements Act requires that the government purchase products that are made in the US or what's known as a, oh my God, I just slipped my mind. What is it, Tara? It's not qualifying country.
Domestic regime country.
Yeah, there's another word for it though that just slipped my mind, and I apologize. It's the US or a designated country. Thank you. And the designated countries are European countries, Caribbean basin countries, less developed countries. There's over 100 designated countries, including, importantly, Taiwan. So China is not a designated country. Taiwan is a designated country. And there's a long list of the designated countries in the FAR that you can go and look and see if the place where your product is manufactured qualifies as a designated country. And then Berry Amendment, this is a DoD unique requirement that requires certain things purchased by the Department of Defense to be made in the US with US content. This is a restriction on DoD funds. So it only applies to DoD contracts, and it applies to things like food, clothing, fabric, hand and measuring tools is included in there. And specialty metals used to be included in there, but it is now in its own statute. And that requires that for DoD, certain specialty metals must be made in the US, melted and produced in the US for certain types of acquisitions. Generally, your acquisitions of things like planes, ships, tanks, things like that. The balance of payments program, this is also a DoD unique requirement, and it applies to supplies and construction outside the United States. And then Buy America with no N are the DOT requirements. There's 5 of them. They're similar, but they're not exactly the same. And they have restrictions on manufacture of products and iron and steel requirements. It has very strict iron and steel requirements that require US made iron and steel. And then we have a whole section we'll talk about BABA, the new requirements. That's divided into 3 different categories. You have your manufactured products, you have construction materials, and you have your iron and steel products. The manufactured products look a lot like Buy American. The iron and steel look a lot like Buy America. And then we have this middle category of construction materials that Tara will talk about. Next slide, please. Okay, so how do we know which regulation applies? Well, it depends on what type of contract you have. If you have a FAR-based contract, you're likely going to have either the Buy American Act or the Trade Agreements Act. If you have a Department of Transportation contract, you're going to have Buy America. And if you have a infrastructure contract, you're going to be under the new BABA. What is the contract value? So currently, for contracts for supplies, contracts over 183,000 are subject to the TAA. Contracts under 183,000 are subject to the Buy American Act, BAA. And then construction contracts have their own threshold, which I think, I can't get to my other screen, but I think it's like 7,038,000 is the threshold for Trade Agreements Act. So anything under basically $7 million is going to be BAA. Anything over that will be TAA. And then who is the acquiring agency? We talked on the previous slide about the DoD specific requirements by Berry Amendment and balance of payments. And then we talked about DOT having their own regulations. And then I'll talk for a minute about qualifying countries. So for Buy American, there is an exception at present in the DFARS that allows DoD to treat products from qualifying countries the same as US made products. And your qualifying countries are going to be your European countries, Canada, Japan, interestingly, Turkey, because Turkey is not a TAA country, but it is a qualifying country. So there's a list in the DFARS at 25872-1 that will tell you what the qualifying countries are. Next slide, please. Continuing on, what are you buying? What items or services are you buying? There are certain items that are exempt from the BAA because the government has determined that they are unavailable. That list is available at FAR 25-104. It's published in the Federal Register as it's updated every couple of years. So if you have a particular product that you feel should be on that list, when that Federal Register notice comes out, you can submit comments to suggest that they add that product to the list. And then certain services are excluded. There's a list of services at FAR 25-401 as opposed to 104 for the products. 401 is the services, and it will tell you what is exempt from the requirements. Here are some examples here: military services, R&D, transportation. And then the COTS, we've already talked about the COTS exception under the Buy American Act. If your product is not predominantly iron and steel and qualifies as COTS, then you don't have to worry about domestic content. What is the product made of? We talked about the specialty metal restrictions, and we talked about the restrictions for iron and steel products. And then where is the contract being performed? So if it's being performed in the US, it generally must comply with the BAA, setting aside the DoD exception for qualifying countries. And then if it's performed outside the US, the balance of payments program applies. And then TAA applies to both products and services. So Buy American Act does not apply to services. Trade Agreements Act applies to services. And the rule there is wherever the country where the company performing the services is established is your country of origin for services under the TAA. All right, it's a lot. Next slide, please. So you can see this is a good summary of what I've been talking about for about the last 10 minutes. It's simple, right? Is it BAA? Is it TAA? Is it something else? Who's the agency? What's the value? There are a lot of questions here. So with that, I'm going to turn it over to Tara to talk about BABA.
All right, good afternoon, everyone. My name is Tara Hopkins, and I'm going to be talking about our newest item in the domestic preference regime, which is the Build America, Buy America Act, as Sheila's previously stated, BABA. The BABA Act is established as a new domestic sourcing preference that is specifically related to federal financial assistance for projects that come under the infrastructure umbrella. Most significantly, the Biden administration Infrastructure Investments and Jobs Act is what really pulled this back to the forefront of our attention and has made BABA the most recent domestic sourcing item that is on everyone's mind. One of the biggest reasons for this is because it's frankly very vague and very confusing to follow. It specifically states that none of the funds made available for federal assistance programs for infrastructure may be obligated for a project unless all of the iron, steel, manufactured products, and construction materials are produced in the United States. There are at least 7 different sections of that quote that can be broken out and really questioned here. What are iron and steel? There are very different definitions in Buy American Act, Buy American, and all of the previous regimes that Sheila just talked about that are technically separate, though very similar in the BABA. So all manufacturing processes from the initial melting stage through the actual application of coating must occur in the United States for iron and steel. That's a much stricter requirement than we've seen in the past. Construction materials is probably one of the newest and most confusing elements to BABA. We haven't seen that incorporated in many of the previous domestic preference regimes. And under the BABA Act, it states that all manufacturing processes for the construction material must occur in the United States. I'll talk more about that in just a minute as well. It goes on to state that the manufactured products must be manufactured in the United States, and then it has a cost component. So the cost of the components of the manufactured products that are mined, produced, or manufactured must be greater than 55% of the total cost of all of the components, meaning that 55% has to be within the United States in order to qualify as a BABA accepted product. Some other key definitions that we need to look at before we really dig into what these items mean. What is infrastructure? Obviously, the Infrastructure Investments and Jobs Act added a lot of possible projects and sources of money and contracts for construction, but also some other infrastructure related projects as well. So we need to look at anything that includes a project for, at a minimum, structures, facilities, and equipment in the United States, specifically related to roads, highways, bridges, public transportation. I'm not going to go through this whole list, but it is an extensive list of various infrastructure related items that fall under BABA's new regime. There has been a waiver process established under BABA, and that is run through the Office of Management and Budget, or OMB. And probably the most inconsistent item with BABA is that it requires that it be applied consistently with the other US international trade obligations. That might seem confusing considering different things apply at different times, but as Sheila just discussed on that slide, as long as you're answering these questions in order and in sync, you should be able to find out which domestic preference regime applies to your specific project or your specific question. I know it seems confusing, but there is a process here that has been put in place, and the BABA is trying to make sure that that consistency stays in its new regime as well. Finally, BABA also does preserve the legacy domestic content preference program. So basically codifies the previous domestic preference regimes that Sheila was just discussing as well. Okay, next we're going to talk about the OMB April 22 guidance. So as Sheila mentioned at the beginning of this, the OMB guidance is exactly that. Guidance is not a requirement. It is not any statute or law, and it is up to the individual agencies on if they are going to adopt the OMB guidance. But what the guidance recently said is that it required the incorporation of the Buy America preference in the terms and condition of each award with the infrastructure projects. It also clarified that the 2 CFR 200.1, whether or not funded through the Infrastructure Investment and Jobs Act, is applicable here. We've already discussed that it preserved the legacy Buy American regimes. And so the guidance basically just reiterates this point that was already included in the original BABA language. Next, it also, the guidance specifically stated that this new regulation is applicable to financial federal assistance that was in place or adopted on or after May 14th, 2022. This might be the most important element from OMB's guidance because it gives a hard date or line for when this goes into effect. When we were discussing the different applicability of the iron and steel manufactured products and construction materials, the OMB guidance goes back to limit it to only those materials being used on the infrastructure projects themselves, not a blanket application to any project overall. The guidance issues a process for waivers for different items for public interest, non-availability, and unreasonable cost. But again, these waivers are included in guidance and are not necessarily requirements. So it's going to depend on how each different agency or where your contract is through as to how that agency is processing waivers. We have seen the waivers process be a little inconsistent between different agencies as they are trying to implement this new infrastructure. Manufacturing and construction materials include both the final and the immediate preceding manufacturing stage. So this is not just your final product. It also includes the process to get it into the final product when you are looking at your percentage and allocation of where the materials are from. And finally, we have an example of award terms imposing the new Infrastructure Investment and Jobs Act, or the BABA requirements. And it would look something like limited to items consumed in, incorporated into, or affixed to an infrastructure project. So this is important because when you are looking at your actual contracts, if you see terminology or language like this, it's likely that the BABA applies. All right, now we're going to talk a little bit about the February 9th proposed rule. The difference between the OMB guidance and the proposed rule is while the guidance is not mandatory for agencies, if the proposed rule were to be finally adopted, it would be required that all agencies would follow the new rule. So the regulations provide consistent structure and detail for the agencies to implement these new statutory requirements following Congress's intent. And that's would give greater consistency to the agency implementation of these regulations. Further, the BABA has directed OMB to issue standards that define all of the terms. And so the proposed rule would make those definitions codified. The BABA has also authorized, but not required, OMB to amend the CFR to ensure that the domestic requirements are, as part of this and federal law, are implemented through the terms and conditions of the award for the federal financial assistance. That sounds confusing, but basically what it does is it gives OMB the authority to make sure that this is being enacted consistently and that the actual regulations have been amended. Finally, this is the next step from OMB's guidance, which was a preliminary item. The proposed rule is intended to take this a step further and really start pushing this in a direction that is more consistent and will provide more clarity for contractors. All right, so what changes would this proposed rule actually make to BABA versus what the actual requirements, not just guidance, are now? While it would still be guidance to the agencies and it's subject to the adoption of individual agencies, it would add the new CFR Part 184 and provide these specific definitions. So construction materials, infrastructure projects, and iron and steel projects produced in the United States would officially be added into the regulations and would be part of those definitions that are the requirements for the agencies. This would also apply the Buy American preferences for all federal awards for infrastructure projects. It would establish that the cost of the components would be adopted, or it would adopt the FAR approach for the cost of components, which is an item that Sheila had discussed earlier related to the Buy American. And it would propose standards for assessing the origin for the construction materials, which is an area that is still vague right now and needs to be further addressed. Finally, it provides a more detailed basis for waivers and some exceptions such as disaster relief programs. All right, with that, I am going to hand it back over to Sheila. Sheila, you're on mute.
Yes, I am. I just got a big notice across my screen. So before we move on, I just wanted to make 2 points on the proposed regulations for BABA. The first is how that works in practice, which may not be that relevant for everybody on the call, but how it works in practice is each agency will adopt those regulations. So for example, Department of Energy, their grant and agreement regulations are under 2 CFR Part 900. And the first thing you see when you go to 2 CFR Part 900 is an adoption of 2 CFR Part 200, which are OMB's guidance on grants and agreements generally. And so what we'll see is an adoption of Part 184, except as amended, and then each agency can amend as appropriate. And one of the ways they may want to amend is that language that says BABA has to be consistent with international trade agreements. So for our transportation projects, we have an exception in almost all of the trade agreements that says that trade agreements don't apply to construction projects. Well, here, infrastructure is defined so broadly, and things like fiber optic cable are listed as construction materials. So that does not necessarily conform to the trade agreements. So there's some work that needs to be done to create exceptions to comply with those trade agreements. And then we can also see things like we have for Buy America, like a de minimis exception or a small purchase threshold. It's, the agencies can adopt those as they see fit, but as long as they implement the guidance. So just a couple more points on that. And now we'll talk about enforcement and best practices. So next slide, please, Tara. So how do you enforce these domestic preferences? I mean, we know they're out there, but how does the government enforce them? Well, first, your competitors can enforce them through bid protests. If you are bidding on a project and you don't have appropriate domestic content in there and your competitor files a bid protest, they most likely will win that bid protest. That's one way we see. And then also GAO agency, offices of Inspector General, and DOJ investigations and audits. I will say you're most likely to see Office of Inspector General investigations in this group. And then if the OIG finds something like you're not in compliant and you've been submitting false certifications, they can refer the matter to DOJ. You'll have an idea that your matter has been referred when you receive either a civil investigative demand or a subpoena in connection with the project, and they'll be asking for things like all of your certifications for your content to make sure that your project is compliant. Non-compliance with the domestic sourcing requirements is a cause for termination. So you could get a termination for default if you are not compliant. Then if you have a termination for default, the agency can charge you for reprocurement costs. Replacement of non-compliant parts. I actually have had this happen on a Department of Transportation project. I got a call one day where a contractor was relying on the small purchase threshold and they were not relying on it correctly. And they ended up ripping and replacing about $300,000 worth of material. And I think it cost them more to rip and replace than they could have possibly made on that project. So that's something that you don't want to put at risk. So you need to make sure you understand where your supplies are coming from. And then mandatory disclosures. I mean, government contractors know one of the things that we have in government contracts is you have to tell the government. If you don't tell the government and the government finds out, then your resolution is significantly worse than if you go in with a mandatory disclosure and get your disclosure credit on the front end. And then what everybody is afraid of when it comes to government contracts, False Claims Act liability. You are certifying that you comply. You have to certify that you comply with domestic sourcing requirements. If you falsely certify that, that can be the basis for False Claims Act liability. I know that's not the topic of this webinar, so I won't go into that in great detail, but suffice it to say that under the False Claims Act, the government can seek 3 times actual damages. Damages are what the government paid you to do the work, plus penalties of $10,000 to $20,000 an invoice roughly. So when you find yourself in one of these situations in a non-disclosure False Claims Act matter, they're going to come at you with usually something about 2.5 times what they paid you is what they're going to be seeking. Plus you have all the costs of the investigation. So definitely don't want to risk that. Make sure you have all of your T's crossed and your I's dotted when it comes to your certifications on your domestic preference requirements. Next slide, please. Here are some enforcement examples. I will say, when I was a young associate many, many years ago, Trade Agreements Act, False Claims Act cases were very popular. And we worked on probably 10 Trade Agreements Act FCA cases. In those cases, we were able to talk the government into giving us credit for the products that were actually received. But you can imagine that there were a lot of, when you consider GSA schedules where the government buys, office supplies and tools like Home Depot type tools, there were a lot of products out there that were Chinese. And so it kept me busy for about 4 or 5 years when I was a young associate just working on these TAA False Claims Act cases. Here are some of the more recent ones. I won't read them to you. You can see them all here, but just suffice it to say that these settlement amounts you see on the screen is probably a multiple of what was paid to the contractor under those projects. All right, so now we'll go to happier things like what are common issues and how can you avoid the pitfalls. You should obtain and you should retain your certifications from suppliers. And how long should you retain them? I would retain them for 10 years. And why is that? Because the statute of limitations under the False Claims Act is complicated, but it's basically a 3, 6, 10-year statute of limitations, with 10 years being the outside. So in some cases, the government can go back 10 years on an FCA case. So you want to retain those certifications for 10 years. Communications, all of the emails that you send back and forth, you want to keep those emails to show that you're doing your diligence. You want to understand if your supplier is changing its supplier, make sure, even if you have a certification from last year, If you're buying that product again this year, you want to ask this year to make sure that they haven't changed their sourcing. We saw a few years ago, there was a lot of changing of sourcing, less so now, but that could be coming back too. And then see clarification. If you have questions, if something is unclear, ask the government. If the government doesn't answer you, document your file. We asked this question, this is how we're interpreting it. The government didn't get back to me, but keep all of that documentation to show that you're acting reasonably. Always, this is always good advice when selling to the government. Misapplication of the substantial transformation test. So the substantial transformation test, we didn't talk in detail about this, but this is a Trade Agreement Act requirement that products be manufactured or quote unquote substantially transformed in the US. There's been some changes in the case law on substantial transformation in recent years. And so you're going to want to make sure that if you're relying on substantial transformation and you have something like assembly, that you take another look at that and make sure that the type of assembly you are doing is complex enough that it is called a substantial transformation. Because again, you know, if you're certifying something is TAA compliant and it's not, you have that False Claims Act risk unless you can show that you took reasonable steps to make that determination. And then failure to complete certifications properly. And this goes back to what are you certifying to? What is the underlying regulation? And you will want to have the documentation to when you sign that certification that you're confident that whatever you're certifying complies with whatever regulation is required for that product. Tara, did you have any thoughts on these?
No, I don't have any additional thoughts. I do think that the biggest issue that we have seen is the recent substantial transformation issues, but then also failure to certify under the correct regime. So, as Sheila just said, making sure that you're following that path and that you're under the right standards for your certification is, while it may take more time up front, it will save contractors a lot of headache on the back end.
Good point. All right, and then moving on to best practices. The obvious, read the contract. If you have a question, read the contract, see what clauses are included in the contract. You can look up those clauses, they're available online. Consult with your experts, consult with your legal counsel, really understand what does this contract require and what are we certifying to. Any other thoughts on that?
No, and the biggest key with reading the contract is just keeping in mind when the contract was signed, because those dates, as we saw for BABA, there are key dates where certain regimes come into effect, and just making sure that you're reading the contract in the context of when it was signed so that you can make sure that what your, what regime you're following is applicable or the correct for that time period.
Yeah, and I guess the only other point I would make on that is sometimes you'll receive like what's called an IDIQ, indefinite delivery, indefinite quantity, or a master contract from the government that the government can then place orders under. Sometimes that contract, because it doesn't have a minimum amount, that a minimum requirement that is a minimum value requirement that is above the BAA threshold, you'll get both the Buy American Act and the Trade Agreements Act in that contract. And the reason you get that often is because they don't really know what the ultimate value of that contract will be. And if it ends up under 183,000, you're in Buy American Act. So you want to be careful in a situation like that to understand what you're providing. And, is it both BAA and TAA compliant? Because the government can buy American Act products that are not compliant after applying what they call an evaluation penalty or, a certain amount over and above your price. So if your product is from a foreign, if your product's from China and you want to sell it on a Buy American Act contract, you potentially can if you certify the products from China, and then the government makes the decision that the price that you are asking for your Chinese product is still worth the acquisition compared to the price of the domestic product. And that can certainly happen with China. So just kind of a sidebar there. All right, next slide, please. Communication. So I talked a little bit about this. Communicate with the government, communicate with your customer, document your file. The end of the day, you have that False Claims Act risk. You want to be really careful here, and just really pay attention to your supply chain, and then seeking waivers if necessary. If there's not enough domestic product available, you may be able to get a waiver for that.
Yeah, and following up with that, keep in contact with your contracting officer, providing the agency advanced notice of any changes in your supply chain. If that happens, will save a lot of time on the back end when you go to finalize these certifications, if you've been upfront about changes or issues as they come up in the process.
All right, supply chain management. I think we've gone through a lot of this. Check your COO. If it's been a significant amount of time, double check before you order again. We haven't talked about flow downs. So interestingly, the domestic sourcing requirements in contracts are not a required flow down. However, if you're the prime contractor or you're a higher tier subcontractor, you want to flow those down because they're necessary for your compliance with contract requirements. And there is a provision in the flow down requirement section that says prime contractors can flow down additional clauses necessary to make sure they're in compliance with their requirements. So if you have a subcontract or a lower tier subcontract, look at those flow downs, see what's been flowed down. And it could be your order's only for $10,000, but it's subject to the TAA because the value of the prime contract is what's going to determine what domestic sourcing requirements are included for subcontracts. So let's talk a minute about commercial products. So commercial product, there's a difference between commercial off-the-shelf products and commercial products. Commercial products can be of a type, or they can be minor modifications to meet a government need. So this is again outside the scope for today, but just be aware that there's a whole regime out there that you can use to determine whether a product truly qualifies as a commercial product. And then there's another one that determines whether a product qualifies as COTS, commercially available off the shelf. So just something to keep in mind, not to confuse things further, but the COTS items that you're looking at to not have to do the content test for BAA must be actually sold in substantial quantities in the commercial marketplace. So if somebody comes to you and says, my item is COTS, so I don't have to worry about domestic content, but they don't actually sell the item, it's just offered for sale, that item is not COTS. It may still be a commercial product, even if it's not sold in the commercial marketplace, if it's offered for sale, and if it's a minor modification from a commercial product, but it's not COTS. So just something to consider. You can be held reckless if you just take a contractor at their face value when you know the product really doesn't qualify as COTS. And then we talked about updates on COO. Those change, there are sourcing changes. So you want to know as you're ordering, where is the COO today, not when was it a year or two ago. And that brings us to the end of our slides. Do we have any questions?
All right, please type in any questions that you do have. Right now, we don't have any waiting in the queue, so if you do, please type them in. And I'll just take this time to just thank everyone for spending the past 45 minutes with us. We really appreciate you taking the time out of your busy schedules to join us. Thanks to Sheila and Tara for boiling down this very complex subject. I learned a lot just listening to it, and I was thinking I'm very glad I'm not still a contractor and having to deal with this. It's only getting worse, it seems. So I think your knowledge and expertise in this is only going to be more valuable as the years go on. So right now we don't have any questions. Just again, if you have a project specific question, please reach out to Sheila and Tara. I'm sure they'll be happy to help. And with that, we'll wrap it up. Look for an email from me with the PDF slides. And thanks again, everyone, and have a wonderful day.
Thank you, Zach, and thanks everyone for joining.
Thank
All
you.
right. Bye.
Bye.